Thank you, Tanya, and welcome everyone. As a member of the Libre Open Access Working Group, I'm really happy to moderate this session today. This is an exciting time of transformation in scholarly communication. And at the Libre OA Working Group, we have been exploring many different ways that libraries are driving openness in scholarly communication. We've been focusing our efforts on everything from supporting infrastructure to supporting open access for ebooks, ensuring accessibility of scholarly content, and of course, what I personally work on, the driving the open access transition in scholarly journal publishing. So, for example, we've been working on updating the Libre 5 principles for open access negotiations with publishers, which we will hopefully be bringing to a close in early next year. But I'm sure, as is the experience of all of you, we've been working so hard, and we are really starting to see results, and that's quite exciting. From my own perspective, one of the lessons I've learned in recent years is how many different approaches and strategies actually work together, right? In the past, we might talk about where we are adopting the green route or we are adopting the gold route. And, that sort of division, I think we've all sort of moved beyond that and are really looking at taking comprehensive approaches to open access. So if we really, really want to achieve open access on a large scale and have 100% of the outputs our institutions are producing being openly available and usable by the world, we really have to have an approach that is inclusive of many different strategies. So for me, that's what makes today so exciting, is because while I have been focused a lot on publisher negotiations, I'm really excited to hear about another strategy, which is that of secondary publication rights. Today, we have speakers, very knowledgeable speakers that have been involved in Recreating Europe, this project, which is rethinking digital copyright law for a culturally diverse, accessible, and creative Europe. So without further ado, I would like to introduce the speakers. We will start out with Giulia Dore, who holds a PhD in European and Comparative Legal Studies from the University of Trento. And she's currently a postdoctoral research assistant at the University of Trento, Faculty of Law, where she teaches copyright law and art. Her research interests include the interplay of social and legal norms in the framework of intellectual property rights, the legal framework of arts, particularly in copyright, the impact of digitization on galleries, libraries, archives, and museums, and cultural heritage, and the broader development of open science. She's a member of the Fondation pour le droit de l'art and of the Institute of Art and Law. I'm going to go ahead and introduce all of our speakers first, and then that way we can go straight into their presentations one after the other. So our next speaker will be Erna Sattler, who is a copyright lawyer at Leiden University Libraries, where she advises the university community on copyright issues, policy making, implementation of new legislation into university regulations, and of course, advising academics on copyright in their research and teaching. She is a member of the legal committee of the Netherlands Library Forum, the copyright working group of Dutch cultural heritage institutions, the copyright and electronic learning environment working group of the Association of Dutch Universities, and the network copyright experts of Dutch universities, and is also a member of the Libre Copyright and Legal Matters Working Group. And our third speaker today is Marta Arisi, who is currently a holder of a research grant at the University of Trento Faculty of Law, where she works on open science at the intersection of intellectual property and personal data protection. And she collaborates in the EU-funded project Recreating Europe, of course, which is why she's here today. And her research interests are informed by a comparative approach and with regard to human rights, data, and the algorithmic society. So in terms of organization of our session, we will have the 3 contributions of our speakers. So listen closely. Please, if you have any thoughts or questions or comments, please feel free to post them in the chat. We will have plenty of time at the end of their presentations to discuss their work and to respond to any questions that you might have. So please go right ahead and post them, and we will get to them later. So I think we can now go ahead and begin with Giulia, who will start us off with an overview of existing models of secondary publishing copyright legislation in a few European countries. All right, so Giulia, I'm happy to pass over the word to you.
Is it working, my microphone? Okay, cool. So good morning, everyone, and thank you very much for being here this morning with us. Thanks, Tatiana, for your warm introduction. And, you are always an exceptional host. Even this time, you were very nice. And thank you, Colleen, for your kind presentation and significant introductory words. We'll be discussing some of the issues that you raised. I'm very interested in that. I'd like to mention that, unfortunately, Professor Roberto Caso could not join us, as today is graduation day in our faculty, but he really wants to send his warmest greetings to all of you and to thank the co-organizer of this workshop. I'm sure that there will be other occasions to discuss with him such a relevant topic, not only in his capacity of copyright scholar, but also as a president of the Italian Association for the Promotion of Open Science. This said, what I'm going to shortly present today can be also found on a recent paper, of which we published, Roberto and I, a preprint on Zenodo in open access, of course. We'll be sharing the link of this publication with you shortly, if you're interested and curious to read it. We'll be very glad if you could send us your comments and suggestions. After some premises on what Roberto likes to describe as a dreadful transition from virtuous academic copyright to vicious commodified wine, we'll move into the core of the subject. So please, Marta, can you turn the slides to the outline? Thank you. Thank you very much. So this is the outline, just to give you an idea of what we'll be discussing. So after this short introduction of this transition from a virtuous word to a vicious word, we'll be discussing the strategies to implement green open access. So our focus, the focus of our presentation is on green open access through, in particular, legislative means, with the enactment of a secondary publication right. We'll have the chance to look at some of the legislative examples in Europe, as Colleen said, before I give the floor to Erna, Sattler, and Marta Arisi, who will respectively discuss more details the Dutch operative and indeed tested model, and the Italian proposed bill, which is still tentative, as Marta will explain. Conclusive remarks will ideally follow our panel discussion, so please stay until the end for our discussion. Now, I'll begin, please, Marta, turn the slide. I'll begin by putting some emphasis on the shift from the virtuous cycle of academic copyright to dangerous commodification we are now witnessing. This not only serves as a background for our discussion to discuss the opportunity of a second publication right, but I believe that it justifies its importance and its urgency. Such a transition sees authorly and scholarly authors with very little, if any, freedom and responsibility on whether, when, where, and what to share their knowledge with the public, reminding that the public is the first recipient, the first addressee of the author, and is founder indeed, but also the reviewer. In a virtuous world, authors are free to channel their public use of reason in the way they see fits best, and they are also held responsible for that. In this world, authors are given the opportunity to disseminate their thought, their knowledge with the widest possible audience. In the vicious world, instead, the market rules predominate, and generally a handful number of publishers set the game for publication and for evaluation to some extent, leaving author often, not always, and the public with little to do. In this world, competition prevails over anything, and so are aggressive publishing practices. The prominent role of authors and those who spread the knowledge risk indeed to depart from their special role they've always had in the virtuous world. And open access helps to challenge this perilous deviation, and it intervenes on this disruptive mechanism. It does so, and you can turn the slide, Marta, through main routes, gold and green open access, even faster, because I realized that I'm asking Marta because last time I had trouble with the connection. That's why I cannot share the presentation with you. So please, we'll share the presentation with you afterwards, even if I jump from one to another slides. It's just my responsibility. So please excuse me for that. So you can also go ahead, because I think that these illustrative figures are better to be understood when you read the paper. Right now, since also for the time constraint reason, I think that we should focus on the other part, so the more operative part. I was saying that there are different ways, as you all know, because most of you are experts in this field, two ways to implement open access: the gold, and Colleen mentioned that, and the green open access. Focusing on the gold open access, we know that this consists in the possibility to publish since the very beginning, so ab initio, with open licenses, and the example can be the Creative Commons licenses on open access venues, and for instance, open access journals. The green road, on the other hand, consists in republishing and communicating to the public via the internet. This is an important specification in open access venues, or using self-archiving open access repositories, works that were previously published in known open access or in closed venues. So our focus, as I said, is on green routes, and also in particular on one of the two main strategies to implement that, which are the contractual and the legislative, but we'll be focusing on the latter, so on the legislative. In fact, let me just briefly say that to compare the two, in the first case, so in the contractual, with the contractual strategy, authors negotiate with the publisher to retain the right to republish and communicate the work to the public in open access. This can be certainly done through transfer agreements, so if the license to publish provides such a right, or through additional contractual agreements that are added to standard publishing contracts, and they are often called as addenda in plural. But most of the time, this strategy is difficult. We all know that it's difficult, especially if the author is negotiating with the publisher alone, with no support whatsoever. And it is also to be noted that the author has usually certainly a more limited bargaining and negotiating power compared to the publisher. And also that publishers, let's say, hardly grant at least unconstrained secondary publication rights, so with no limitation at all. And here's where the legislative strategy intervenes, as it tries to tackle these difficulties that have arisen from the contractual strategy. And that's why we have some countries providing the second and often expressly called digital second publication right. The first to implement this strategy, so Marta, please, you can go ahead and show the table that we created. Yes, Thank you very much. So I understand that it's difficult to see all the content there, but when we'll share the slides, everything will be clearer. Perhaps we can zoom it a little bit if it's possible. So the first country I was saying to implement this strategy was Germany back in 2013. And we all know its legislative model as a pioneer model that later circulated in other countries, in the Netherlands, in Austria, France, and Belgium, first of all. The writing question has found other tentative application in other countries, certainly in Italy, as Marta will explain, where still, however, strives to become law. So it has not become law yet. We've made this table to help you understand the difference and the similarities among all these different examples. But let me just briefly anticipate that the German model, the pioneer model, under paragraph 38.4 of the German Copyright Act, provides a model for the other countries that then have adjusted, so following the same scheme or taking some distances, as the Netherlands in particular, as Erna will show, to make it more practical. The German model provides that the author of a scientific contribution, which is produced in the context of a research activity, and specifies that this has to be at least 0.5% publicly funded, and that appeared in a collection that is published periodically, at least twice a year. So you can already tell that there are already a lot of specification. And in that case, if these conditions apply, the author has the right to make such contribution, such work, publicly available in the accepted manuscript version. So only in that particular version. And also after a period of embargo of 12 months after the first publication. And most importantly, only for non-commercial purposes. So it really excludes any possibility of using it for commercial purposes. And the other specification that he makes, and which is also very important, is that it does not count. So it's regardless this right of whether the author has transferred any exclusive rights of use to the publisher in particular. Such provision in the end also mandates that the source of the first publication has to be indicated, and also specify that any possible agreement that is contrary to the provision and to the detriment of the author has to be considered invalid. This German pioneer, as I said, standard has, however, a limited field of application. So the scope is kind of constrained because of the limitation that I just briefly mentioned. In fact, it imposes a certain percentage of public funding, so at least half, which is quite a lot. A minimal periodical relapse, so twice a year issued. The work can be only the AAM, so the author accepted manuscript version. There has to be a 1-year embargo from first publication, so quite a long period, even if it's homogeneous for any kind of discipline, and cannot be of commercial use. So as we've seen, and we'll see more in details afterwards, the German model circulated in other European countries, being adjusted to some extent. So the other examples are Austria, first of all, that tends to mirror the German model. So I'll speak about that very briefly, just to make sure that we are aligned on that. So it's really mirrored, if not worsening to a certain extent, some part of it. France tries to ameliorate, in fact, provides a shorter embargo for some disciplines, but this can be pro and cons because it is shorter for some disciplines, but it creates somehow inequality. So there is not an homogeneous treatment between disciplines. And then there's the reference to periodical. France issues at least once a year rather than twice. So for the rest, however, France does not really strange from the German model. Thinking also about the restriction to author-accepted manuscripts and to non-commercial use, which I believe are very, very important as limitations. Focus on the object of the provision. I was telling you just before that the Austrian choice is to restrict it even further, in a sense that it provides that the work has to be made by a member of staff of a research institution. So you can see that the scope is constrained again. Regarding the percentage of public funding justifying the application of the right, only the Netherlands opts for a less rigid time, as you can see. And not only, like Belgium, it does not specify anything about the periodical recurrence, just mentioning Belgium here, periodic journal, but it leaves the door open, I would say, expanding more the scope of the provision. But Erna will definitely illustrate more important peculiarities of the Dutch model soon, that makes it shining, in my opinion, in this overall picture. And Marta will compare some of these features with the Italian proposal that is, as I said, still struggling. Thank you. I'm done.
Right. Thank you so much, Giulia, for that overview, which is extremely helpful, I think. And just to keep up with time, I think we will pass things over now directly to Erna, who is going to talk about some of the work that has been done in the Netherlands specifically. Erna.
Yes, Colleen, thank you for introducing me. I will now share my screen for the slides. Secondary publishing right in the Netherlands. How do we organize it? And let's also see how did it all start. Of course, in the Netherlands, we have the Dutch Copyright Act, in short DCA. And in January 2014, one of our MPs, Joost Taveerne, submitted an amendment to the DCA regarding secondary publishing right. It took a while, but a year later, the final amendment was submitted. It is now known as the Taveerne Amendment. It was approved by both Parliament and the Senate. And later in 2015, it became Article 25 FA of the Dutch Copyright Act. What does it say? I will read it to you. The maker of a short scientific work for which the research has been financed in whole or in part with Dutch public funds shall have the right to make the work available to the public free of charge after a reasonable period following its first publication, provided that the source of the first publication is clearly indicated. Now, how did researchers react to this new piece of legislation? In short, they had cold feet. They did not republish or hardly republished. Why was that? Their reactions varied. Some said, I don't have time to upload my paper, or uploading is too complicated. They would say, oh, I forgot all about it. Or they were choosy. They said, I don't want to share the accepted version. I only want to share the publisher's version. But some also reacted, being afraid of legal actions. What if my publisher gives me problems? So universities and the libraries decided to come to their aid, and they asked a reputable expert in copyright for advice. Because one could say that the article in the DCA was a bit vague and it raised questions that needed to be answered, questions like a short scientific work. What is the definition of a short scientific work? Financed in whole or in part with Dutch public funds. How much or how little does in part have to be to still comply with the requirements of this new article? make it available to the public after a reasonable period following first publication. Then what is a reasonable period? So in order to answer these questions, Dutch universities and their libraries came together. They formed a national project group, Tavern. The members of this project group came from the universities, because each university had its own local project leader, Tavern. What was their aim? Their aim was to develop a way of working that would be good for universities, for their scholars and their libraries. What were the answers they came up with? A short scientific work that was defined as journal articles, book chapters in multi-authored books, and also conference papers. They made sure to make it clear to everybody that it did not include monographs nor chapters of monographs. And what version would researchers be allowed to publish? They concluded that that would be the final published version, also known as the version of record. Financed in whole or in part with Dutch public funds. In other words, how much is too little? Because it is true that many articles in journals are multi-authored. And then the case, what if only a small part or even just one of the co-authors has been funded by Dutch public funds? Maybe just one co-author is connected to a Dutch university, and then you can say he or she is funded by Dutch public funds. Well, the project group decided that the inclusion of a researcher as co-author already implies that his or her contribution is of substantial value to the final product and therefore has been financed in part with Dutch public funds. So yes, the work may be republished in the repository of the university in question. Another question was, what is a reasonable period following first publication? First of all, what is the date of first publication? The project group decided that that date would be the date that the published version is made available online. Of course, it is possible that the publication appears as a paper copy in a paper journal before that online date, but that would not count. The first publication is decided to be the date it is available online and not on paper. Then again, what would be a reasonable period following this first publication? The project group concluded that 6 months would be a reasonable period. So this 6 months period would allow publishers sufficient time to earn back their investments. Also, the project group concluded that they did not expect libraries all of a sudden en masse to cancel journal subscriptions due to this republishing. And later they turned out to be right. That did not happen. How did we move on from there? When the project group was finished, they presented its findings to the boards of all the Dutch universities, and the universities together decided to start a nationwide pilot. This pilot took off in early 2019. Scholars employed by all Dutch universities could participate. What did scholars needed to do? If they wanted to have their work republished, they needed to contact the library of their own university. The library would do a check if publications were eligible for this pilot, and then participants needed to sign a license to give their consent. Why was it necessary for participants to sign a license? This was necessary because the Article 25FA states that the maker of a short scientific work is allowed to make it public, and the maker is the researcher, that is not the university. So the researchers had to sign a license to allow libraries to place it into their repositories. The slogan for the pilot was, "You share, we take care." We started a website, openaccess.nl, where all the information could be found. The you in the sentence "you share" is the scholar. The scholar was giving permission for his or her article to be published in open access in the repository. And the we refers to the universities and the libraries. We take care. Libraries would do all the administration, so the scholars need not worry with that. And if any publisher were to undertake legal action, then the universities together were going to be responsible for paying the legal fees. Now, what about the publishers? How did they react? Well, before the pilot started, the publishers were informed. The message was, in short, this is the law, and this is how we interpret it, and this is what we are going to do. What were the results of the pilot? The pilot took 7 months. All 14 Dutch universities participated. 600 researchers from these universities signed the license, and this resulted in 2,800 publications that were shared. Fortunately, 0 legal incidents happened. I share a link with you that refers to an article that gives you many more details about this Dutch pilot. So where do we stand now? The pilot is completed. We feel it was really a success. And at the moment, universities are in the process of implementing the Tavern Amendment for all their scholars and employees. I work at Leiden University. What was Leiden's solution? Leiden has amended its existing labor agreement with all the employees involved. This was quite a task because first you had to make the decision for which employee is this applicable and for which one it is not. Then they had to be sent a letter explaining about the amendment to the labor agreement. So everything legal was taken care of. Of course, all these changes, these legal changes, have also been implemented in the standard labor agreement that Leiden now concludes with new employees. What does it state? Basically 2 things. Leiden expects any researcher to upload the short works into the university repository 6 months after first publication online. The researcher is allowed to opt out, but if that is the case, then he or she has to motivate the opting out. Now, I've explained to you the situation, how we go about it in the Netherlands, but what about Europe? Allow me to elaborate a little bit on LIBER. LIBER is the voice of Europe's research library community. Its members, about 450 members, are national university and other libraries. And also LIBER has partnerships with other European organizations, such as IFLA and Spark Europe. I provide a link to LIBER. LIBER has also dedicated working groups, such as the Open Access Working Group and the Copyright and Legal Matters Working Group. And yours truly is a member of the Copyright and Legal Matters Working Group. These 2 working groups came together and worked on a pan-European model law for the use of publicly funded scholarly publications. This model law was approved by the executive board of LIBER. And the aim of the model law is actually to provide a zero embargo on open access for European short scholarly publications that are funded with public funds. Why is this necessary? Some European countries in recent years have already passed legislation allowing this reuse of scholarly works, but most of them have not or have not yet. Some points I would like to highlight, some points of this model law on secondary publishing rights. In the model law, these secondary publishing rights belong to authors, their employers and funders, and these rights are not, it's not possible to waive these rights via contracts with publishers. So no matter what the contract says between a researcher and a publisher, these rights cannot be waived. The model law makes a difference between majority public funded and minority public funded publications. If it's majority funded, public funded, then there is full use and reuse by the end user. If it's minority publicly funded, then it allows only reading by the end user. Why would this be good for Europe? If all European countries would adopt this law and implement this model law in their legal systems, it will cause equity of access to scientific output all over Europe. So this concludes my presentation. Thank you for your attention.
Brilliant. Thank you so much, Erna. That was extremely informative. We appreciated both hearing about the Netherlands and the model law that Liber has put forth. Okay, so moving now to our final presentation, Marta will talk us a bit about the situation in Italy. Marta.
Thank you. Thank you so much for the kind introduction. And thank you, Erna, because your speech was really informative, and I'm a bit afraid that I will not be able to tell such a descriptive and also give such a practical view of how things are in Italy, because unfortunately, as we already mentioned, the Italian model is still a proposal. And indeed, I'd like to start with saying that this Legge Gallo was arising from a proposal that was originally meant by the Italian Association for the Promotion of Open Science, AISA. And then this proposal from the association was modified after dialogue with the stakeholders, part of AISA. And then what arrived to the Camera in 2018 was something different. So we're talking about a proposal that was also a bit modified, and that currently is still unfortunately pending before the Senato. So while it was approved by the Camera, it still needs to be approved by Senato, and this is the situation since 2019. A brief overview on what the Legge Gallo does, because Erna was really able to get into having a feeling about what also the universities are doing, what research institutions are doing. And indeed, we have to know that in Italy, this part of initiatives is partially covered by Decree Law 91/2013. And Legge Gallo also proposes some amendments to this decree that already provides for enhancement of open access and scientific publications by the institutions. So that is one side of the proposal, but we're now focusing indeed on another thing, that is the introduction of a new article in the Copyright Act, that is Article 42 bis. And this is consistent with the fact that, as Giulia was already saying to us, the proposal for a secondary right is also consistent with the green route, and in particular the legislative route. So we're talking here about a right that will insist on the author And I think it's really fascinating, the idea that in Italy, this could really have a moral connotation. So being defined as a moral right for the author. So with all the characteristics that are pertaining to this right, the fact that it could be imprescriptible, that it cannot be disposed and not transferable. This is indeed not precluded by the Italian law, and it's coherent with other provisions that really attribute to the author the right of the first publication. So I will go directly into the article, and of course, this is a very rich slide, rich in content, and I don't expect you to read it, but I think this was the best way to illustrate what are really the contents of the provision, and also the differences maybe with the other models that we already saw, but also the differences with the original proposal by ISA that I tried to underline in blue. So basically what we see here, and I think we're able to see the differences already with the models we already saw with Giulia's presentation, is that we're talking about a scientific work. So we're talking about not a short scientific work and not an article, but a work that is published in a periodical. And it should be noted that the original proposal was larger, because in the original proposal, it was something that was not published, and that could be also an article, a monography, or even a chapter in a book, which is also very interesting in light of what Erna said regarding the work of interpretation that the stakeholders did after the Tavern Amendment was published. And again, in Italy, we find already, again, the extent of 30% more by public funds. And I think someone in the chat already evidenced how it could be difficult to know how to calculate this percentage and how to be sure. So this is a problem that is consistent with legal certainty. And again, we're talking about a right to make the work available free of charge. So we're not talking about a manuscript version, but the work free of charge to the public. And again, not for commercial purposes. Also, this was an important addition in the proposal that came to the parliament. And the Italian legislator has chosen also to specify that this work should be available on the internet and in institutional disciplinary electronic archives with open access. So this is an important specification that we see a bit in other models as France, that gives us more details about what should be the venue in which the article work should be published. And again, in terms of timeframes, I think the Italian model mirrors a bit the French model, because it specifies that there is the possibility to do so right away when the publisher has made available the work free of charge, but in any case also no more than 6 months or 1 year, depending on whether the work is in the scientific field or is a work in the humanities and social sciences. Very importantly, a part of the provision that was not modified is that in exercising this right, the author shall indicate the references of the first edition and also specifying the publisher. But even more importantly, the fact that the author remains the owner of the right, even if an exclusive license has been issued with the publisher or editor. And also, contract terms that would be in violation, in breach of these provisions, should be considered null and void. The original proposal contained also a specification that it's common to the France provision, that it's the ordre public connotation, but still we're talking about a right that is really strong, that is capable of remaining with the author despite these circumstances. So that is why we also talk about a moral right, a right that stays with the author no matter what. And very briefly, to conclude, I'd like to illustrate how this really fits the Italian copyright framework. This is both because Article 42 bis will follow Article 42 that already specifies the right to republish in whether the work is part of a collection, and also specifying that this is possible also when the article appears in magazines or newspaper, but mostly Article 12 that is indeed referred to possibly the right to disclosure, so a moral right that stays with the author to choose when to disclose his work, and evident expression of his right of personality that becomes embodied in the work. And this is why I'm really persuaded that we can talk even for secondary disclosure about a moral right, at least in the Italian system that embraces moral rights in its copyright framework. I may have gone a bit fast to illustrate all the content, but that's what I wanted to say. I hope it's clear, and of course I will be happy to take any questions about this model that unfortunately remains a model, but we're closely monitoring these developments at the Parliament. Thank you so much.
Brilliant. Thank you very much, Marta. Okay, that concludes the presentation portion. So now I would like to invite everyone here on the call, if you feel comfortable, we'd love to see you. That way this becomes a group discussion. And please, especially my speakers, please go ahead and turn your microphones on together with your video monitors, your cameras, excuse me. At this point, I've been noting some of the questions posted in the chat, and I will go ahead and begin with them. Before getting into the questions that I will raise to our speakers in the order that they came in, I did want to say that we've seen some comments and questions in the chat regarding the Liber model law, and for that, I think we will take those comments and we will pass them directly to that working group. Okay, I don't think that we are actually in a position here today to address those questions specifically, but we will pass them to the working group and raise those comments to them. So getting into the questions that I've noted so far, the first came from Robert Kiley of Coalition S, wondering, as he was watching Erna's presentation, how much opposition did the legislation that was created in the Netherlands receive from publishers? I mean, for example, taking the point that Elsevier, for example, is based in the Netherlands. Erna, would you care to comment on, and then we'll hear also from Marta and Giulia, but in the Netherlands, what do the publishers have to say about this?
Well, they have been surprisingly quiet about it. And of course, they will still, with individual researchers, sometimes try, put it in a contract that it is not allowed. But actually, there have been no legal proceedings. There have been no letters from lawyers, from any publishers. So I guess they've come to realize that this is actually the law, and this is how it is, and this is how it's going to happen. And of course, I have to mention, this new article is explained as just a reading right of the end user. So it is not total open access, so they can reuse the product, the article. You can read it, you can share it via a link, but you cannot, for example, translate it in another language and then use it for your students. So it is only a reading right in the end.
Okay. Okay, maybe I'm also interested in hearing, and perhaps Marta or Giulia, you want to comment on this. What about publishers putting up resistance before the law is actually put in place? I mean, have we heard anything in that respect?
Oh yes, definitely much resistance from the Italian Publishing Association. That's probably why the bill is still pending before the Senate. Perhaps there needs to be more discussion. So there should be more discussion among all the stakeholders, which is something that ISA, the association that originally promoted this bill, and Recreating Europe is trying to do. But apparently there is not enough debate among all the stakeholders, and particularly at the level of libraries and archives, that I think are very, very important in this sense, because as we can see from the Dutch model that was tested, the role of the libraries was determinant and still is determinant to explain some of the more obscure aspect of these laws. Perhaps the reference to the 50%, at least 50% funding is an example of that, because you need someone to support you as an author to really understand whether you can be within the boundaries of these laws. And it's not really easy to navigate. So I would say that there is still resistance, but there is also lack of how to say information and knowledge to make this law more understandable. And perhaps that's our hope, the hope of those who are now thinking about making a petition, like a larger petition, so the population, the people can choose to make sure that this becomes really a law. But as you know, with the petition, you need a lot of signatures. So it's something that ISA and other stakeholders are thinking about, but it's not really ready to be a reality.
Okay, right. I will move on as I promised before, and take our questions in chronological order. I know some other folks have added questions, and folks have raised their hands, and I will, if we have time, we'll get to everyone. The second question that I noted was from Hjalmar Visser. This is also a question for Erna, but about the phrase in the article, financed partly or in whole by Dutch public funds. What about research that's funded by the EU? Do you consider that to be Dutch public funds, or what's your approach there?
Yeah, that's a very good question. And the answer to the question is yes, we do consider it to be partly funded by Dutch funds. Why? First of all, even if a researcher receives a grant from the EU, then still the university has costs. The researcher needs an office. There are all sorts of facilities that he can take advantage of that are in the university. So there's, of course, he has access to the library. So we consider that reason enough to be partly funded by Dutch public funds. Also, even if it is an EU grant, the Netherlands is also a member of the EU. So a lot of Dutch money goes to the EU that is used for research. So then actually part of that money comes back to that was financed by the Netherlands via the EU is coming back to the Netherlands. So then that would also be a reason for the research to be considered partly funded by Dutch funds.
Thank you.
Just one small thing. I'm sorry to interrupt.
No, please.
Maybe of interest that this is a very good question also, to the point that, for instance, in the French legislation, this is specified. So EU funds are included specifically in the text, but this is really exemplary of how even after the law, we are dealing with legal certainty and interpretation problems. Just wanted to add that.
No, that's great. Yeah, so we have a lot of questions about the funding. Another question, the next question is about, like, how can we establish with certainty, like the specific percentage, 50%? How do we do that? Any of my speakers?
As I was saying, that there are libraries and also associations that are trying to help authors to determine with some certainty all of these boundaries. But indeed, in the end, it's really something that must be assessed on a single basis. So it cannot be said with certainty when it's going to be 50 rather than slightly less than 50, unless this is made clear by an amendment to the law, or by like some addendum to the law that makes it clear, or unless it goes before the court. In that case, probably is the best way to clarify things is that a judge decides and determines how really to establish that. But again, I really think that the help of libraries and associations like the Alliance of Science Organization in Germany is really crucial to this extent. I could not retrace the set of frequent asked questions that the Alliance of Science Organization prepared for the German authors, but we will certainly find a way to share them with you.
Great. Erna, did you want to add something, please?
Yes, thank you. Yes, it's very interesting that we find this 50% limit in Germany, now in the Italian proposal, and even in the suggested pan-European law by Lieber. At least by Lieber, it only refers to full reuse or just the reading right. But even if it is less than 50%, it can still be published online in open access, only you do not have the full reuse rights. And therefore, I shared a link in the chat. There is an explanation about what is the meaning and the exact wording of the pan-European law suggested by Lieber. I have added there in the explanation a phrase that when the research is being done by researchers that are employed by university, then that itself, it is considered more than 50% publicly funded.
Very interesting. Yeah.
That, and you could consider that for the German and the Italian model as well. If the researcher is employed by a university of that particular country, then you define it as more than 50% publicly funded.
Brilliant, thank you. Another, I guess, a related question. Robert Kiley raised this and mentioned in the UK, there is a long history of charities funding research. You know, you've got Wellcome Trust, Cancer Research UK, British Heart Foundation. I know in Italy, it's also very similar. A lot of the research comes through private funders. And so is that something that's missing from this legislation by talking only about publicly funded research? I mean, how do we bring into consideration private funding? Any thoughts, anyone? Erna.
Yeah, that's really a good question. And it could be an oversight by the Dutch legislator. And of course, the focus was really on research publicly funded, because publicly funded means that it's taxpayers' money. And if it's taxpayers' money, then that is paid by citizens. And the citizens pay for it. And why should they not be entitled to read it and benefit from it when it's paid for by their own money, so to speak? So the focus was indeed on publicly funded research and not by the privately funded research. So, but of course, their research, they should set, perhaps it's an idea that they should set their own standards for themselves and say, look, if you publish in a journal and it's paid for with our money, then we preserve the right to place that article in open access. So they could set their own standards. That would be my advice.
Yeah, from Italy, do you want, Marta or Giulia, did you have any, or from any of the other countries that you've considered, did you want to add anything there? Has any work been done to engage private funders in these conversations?
Well, actually, this would make the arguments of the publisher, in particular those who are opposing the law, more consistent. Because so far we can say that the arguments that they are making, so the fact that there is still entrepreneurial risk, we would respond saying there is not anymore because there is public funding, and also that copyright is not losing its meaning because it's publicly funded, would be not that easy to counterpose. So it's definitely something that is important to take into consideration, but would not have the same, should be addressed in a different way. So should be addressed considering more closely the counter argument that they are making on such extent. So I would say that it's not as easy as it seems to involve a non-publicly not public funding in the picture, but it's definitely something that we should discuss.
Thank you. I think this is just a quick clarification from Floriana Müller was asking Erna, and that regarding the labor law at the university that was changed, is it only new employees that adopted this contract, or was it all employees had to take on this new contract with these new obligations?
Yeah, that's correct. It is not just new employees. Of course, now it has been implemented in the new labor contracts that is concluded with new employees. But also, as I explained, to everybody involved, so the existing employees involved have received a letter in which this legal change has been announced to them. And so they are now under the obligation, so to speak, to share their work publicly in the repository. And there is still an opt-out, but it needs to be motivated. And not many researchers will make use of that opting out because, you know, most researchers, if not all, they just want their knowledge and their articles to be disseminated in the broadest possible way.
Thank you. The next question, I'm still going chronologically here. The next question I had was on the model law. So I don't know if Erna, you feel comfortable responding to this, but it's on what basis are the obligatory rights transfer justified in that law? Can you speak to that?
Yeah, so the obligatory rights is actually the obligation for the researcher to publish in open access, I assume. Is that it? And if that is so, then of course, that is sort of an obligation by the researcher to place his scientific output or his scholarly output in open access. Not only he can place it in open access, but also his employer in the repository if he works at a university, and also the funder can place it in open access, his output, because if, and that is usually the case now, if you get EU funding or other funding, then usually you also get the obligation that your output must be placed in open access immediately. So part of your funds must be reserved to publish in open access immediately. So that would be the golden route. And of course, we focus mainly on the green route. But yes, it would be an obligation for a researcher to do so. And of course, from a copyright point of view, this would limit the copyrights from the individual researcher. But as I said before, most researchers simply want to disseminate their output to the broadest possible audience, so they will not mind. But yeah, in truth, it would become an obligation, yes.
So in another question, this was Sally Rumsey was asking about whether or not, I mean, at this point, you know, time has passed. In the Netherlands, are they considering getting rid of the 6-month period now? I mean, now that you've worked with this.
That's a good question. As for legislation, not yet. But yeah, and there, of course, there's a role for Europe to play. If the EU, for example, were to write a directive stating that they expect their member states to place all scientific and scholarly output in open access from the moment it was written, yes, then the Netherlands would also have to change legislation and get rid of the 6 months period, which of course we as universities and university libraries would welcome very much. But at this particular moment, there are no plans to change Dutch legislation and getting rid of the 6 months.
Giulia or Marta, did you have any other further comments here on embargoes or any action on the European level?
Well, maybe just briefly that the original proposal was mirroring the Netherlands, the one after a reasonable period. But then the one that is currently up to the parliament proposes an embargo. But again, we have to distinguish the two sides of the Italian law that one distinguished, like on one side we have the Decree 91/2013, and on the other side, the right to republish that it's a current proposal to modify the Copyright Act.
Okay. Another quick clarification, Dirk Verven asks, the Dutch authors also redistribute works edited by publishers established in countries where the law does not contain a secondary publishing right. Is that correct? I mean, this is all publications. It's where the author is based. That is the main focus here. Is that correct?
Yes, that is correct. So it is kind of independent of, because a researcher concludes a contract with a publisher for his article to be placed in a journal. And of course, that journal could be based in the United States or in China or wherever. So then you can say, well, maybe the contract is concluded under US law, and then this rule does not count. Well, and this is really a technical legal matter. The Dutch law states that if the contract with the publisher, if no law was chosen, so it's not
Governing.
This contract has US law, or it has British law, or it has Dutch law. If no choice of law is in the contract, or if we pretended there is no choice of law, and then the contract would be under Dutch law, then this article applies. Mm-hmm. So then, of course, it raises the question, if you rule out the choice of law, is the contract concluded under Dutch law? Then, of course, we would say yes, because the researcher who is doing the work is based in the Netherlands. That's why it would be Dutch law. Of course, the US publisher could say, no, but he's not doing the work, he's only contributing. We are doing the work because we are publishing it in the US. So if there is no choice of law, then it would still be under US law. That question has not been solved yet. So if that is the case and there comes a court case, then that will be decided.
Okay, thank you. We are just about out of time, and at this point, before I'll pass the floor over to Giulia, I think he was going to offer some concluding remarks. Before I do that, Erna, thank you so much for your exhaustive answers. Marta, did you want to add anything before we go into concluding remarks?
No, I think I can't add anything on this point, unfortunately.
Okay.
Like,
Okay, that's fine. Great. Okay, then Giulia, did you want to offer some remarks to sum things up or give some perspective toward the future, perhaps?
Well, very briefly, I would first of all thank all of you for participating to this workshop and for giving a lot of insight. So we really appreciate your interest and your comments, because this is what we were really waiting for, so we can really go ahead with our research. Even the question that one of you were posing about the Irish law, personally, I'm not aware of any specific law in a matter in Ireland, but we are still mapping in Europe all the countries that might be interested in enacting such similar provision. For instance, some interest has been shown by Estonian scholars, and we mentioned that in our paper. But I'm sure that other countries have interest in similar provision, especially if we consider it really as the right of the author. So I would emphasize this aspect, closing this workshop, that it's not an obligation, it's not an imposition, it's a right. It's the liberty of the author to really regain power of his work, of what has been produced by him, by her. And this is probably the most important feature of the right, that it's an instrument of liberty, of freedom, and also of responsibility. That's why we suggest it might have a personal, certainly personal, but perhaps even a moral nature, at least in countries like Italy, where the law actually allows you to consider it as a moral right. As Marta says, it really links very closely to the first publication. So this is a second publication, which is connected to the first publication. And if we think clearly, the author has the right as a liberty to decide whether he wants or she wants to publish or not. So to say, it's an obvious, almost an obvious conclusion that even the right to publish again his work, it's still one of his important right and freedom. This secondary publication right was enacted, as we've seen in some countries, but we've seen also the limitations and the constraints of most of the legislations on this regard, and also the undeterminacy, so uncertainty that goes along with any copyright matters. We know about that in the end, if we really want to have a clear answer, and sometimes we will not get a clear answer even there, we still need for the court to decide. So it's really the place where the doubts are ideally resolved, or those controversial aspects are fixed or discussed in a very detailed way. Now, the hope is that really we will have a more harmonized, like this pan-European law that Liber is suggesting is a very interesting idea and should be pursued. But certainly we should consider all the observations that were made today, and we also made on separate occasions to make sure that this becomes an instrument that is useful to all authors in Europe and beyond, but also to the libraries that, again, are so important in this process.
Brilliant. Okay. We are pretty much out of time. So Giulia, Erna, and Marta, I thank you very much for sharing your insights with us today and your experiences. I'd also like to thank Tanya and Liber for hosting this session. It's been very helpful, I'm sure, to all of us. I thank you all for your participation and your great questions and comments, which I think that our speakers will take away. So I guess that's us. Have a wonderful day, everyone.
Thank you very much, Colleen, for hosting today's session so wonderfully.
It's a pleasure.
Thanks, everyone, for participating. I will say this again. We will send you the Zenodo links and the YouTube links to the video shortly after we publish them, so you can have a look and spread the word around to those you think would be interested. Thanks a lot.